The High Court,
Only God can remove me. Words reportedly uttered by advocate Busisiwe Mkhwebane in June 2019. She repeated them on the Twitter account belonging to the Office of the Public Protector in defense of a barrage of criticism. In 2017, the Bancorp CX report was questioned. Her remedial action flowing from that report, calling for the mandate of the Reserve Bank to be amended, set aside. It was also the year she survived a first attempt to have her removed from office. Forward to 2018. The entire Bancorp report is set aside. Mkhwebane loses an application to be personally liable for a percentage of the costs incurred in the Bancorp CX matter. And the Vrede Dairy Project report is released. 2019, another attempt to have her removed from office fails. A court finds she failed in her duties to investigate and report on the Vrede Dairy Project matter. Parliament's Justice and Correctional Services Committee is again asked to look into Mkhwebane's fitness to hold office. 2020, possibly the most bruising year yet for Mkhwebane, starting as early as March when the Pretoria High Court set aside her entire CR17 report. In this report, Mkhwebane investigated allegations that President Cyril Ramaphosa had lied to the National Assembly about receiving funds from Bosasa to fund his election campaign. But a full bench of the High Court found it was not within her jurisdiction to investigate an internal ANC party leadership campaign. The court also found Ramaphosa did not deliberately mislead the National Assembly. All Mkhwebane's remedial actions were declared invalid. This judgment was described as a damning indictment of Mkhwebane's knowledge and application of the law.
We have found, for the detailed reasons given above, that her investigation into the CR17 campaign donations fell outside her field of competence. Further, that her report and the findings and remedial action contained in it were invalid on several grounds. It follows that they cannot stand and must be set aside. In the result, the review of the President, the Speaker, and the NDPP succeed. We make an order in the following terms. 1. The Public Protector's decision to investigate and report on the CR17 election campaign for the African National Congress leadership, elected in December 2017, is reviewed, declared invalid, and set aside.
Another report set aside this year was Mkhwebane's investigation into the Financial Sector Conduct Authority, a decade-old case looking into allegations of impropriety and maladministration at the Financial Services Watchdog. This report, released in March 2019, was taken on review, upon which it was declared constitutionally invalid and unlawful by the Pretoria High Court. Then, most recently, the Public Protector's report into the so-called rogue unit at the SARS was set aside. On the 7th of December, the Pretoria High Court declared this report unlawful. The investigation centered on assertions that then SARS Commissioner Pravin Gordhan was in violation of the Constitution for approving the setting up of this alleged unit. This earned Mkhwebane further criticism.
This last one was perhaps one of the most scathing judgments ever to have been penned about the conduct and ethical standing of Advocate Mkhwebane. The court called into question her honesty in the matter and made a specific a referral of her conduct to the Legal Practice Council, given that she had been found by the court to have been dishonest, to have lied on oath before the court. So these matters, continue the trend of the Public Protector losing these high-profile cases in the courts. What is interesting, I think, is the subject matter of these investigations and complaints and reports that have been done. They appear to be driven by a political agenda targeting people such as President Ramaphosa and Minister Pravin Gordhan, who's seen as someone who's very close to the president.
Adding to her woes, Mkhwebane is also having to contend with the possibility of being removed from office by Parliament. This follows yet another call by the Democratic Alliance that her fitness to hold office be questioned. This is another matter being waged in the courts. Mkhwebane lost an application to have Parliament cease in its investigation into her fitness to hold office. She is, however, still challenging rules adopted by Parliament in 2019, which deals with the removal of a head of a Chapter 9 institution.
These rules are now being invoked in terms of the complaint that has been laid with the Speaker regarding the capacity of the Public Protector, Advocate Mkhwebane, to hold office. The Speaker has now appointed an independent panel, which is provided for in those rules, to conduct a desktop evaluation of the complaint against the Public Protector, and the panel will be required to also consider any written submissions that Advocate Mkhwebane seeks to make to that panel. Theirs is a preliminary investigation, and they will make a recommendation to the Speaker, which will need to be tabled into to the House, as to whether there is a prima facie case against the Public Protector, and whether a more detailed and formal investigation should then follow, which will be conducted by a committee of Parliament.
This panel is led by Justice Bess Nkabinde with the assistance of Advocates Dumisa Ntsebeza and Johan Teval. The time frame given to the panel has been extended, and it's been given 90 days to complete the task.
The panel made this request following their first meeting, as amongst others, the evidence to be assessed is quite voluminous, and also that sufficient time will be required to give the Public Protector an opportunity to respond. The Speaker has considered the request of the panel and is of the view that the request is quite reasonable in the circumstances. It is imperative that the panel is afforded the necessary time required to carefully study the motion and evidence, and as part of its deliberations, also afford the Public Protector a reasonable period to make submissions. As the current rule, which allocated the 30-day period to the panel, does not provide for extension, the Speaker has moved to frame a temporary rule, as it is allowed in the rules of the National Assembly, to close this particular gap.
Mkhwebane is challenging this process. It will be argued in the Western Cape High Court in February. The SABC did ask the Office of the Public Protector to respond to what has been said about her performance and conduct in recent years. After initially agreeing, the SABC was informed by the office that the interview would no longer be granted. Abra Babia, SABC News, Parliament.